there was a dispute regarding whether these, whatever you call them, let's call them tourist homes for today, or whatever you'd like. Tourist homes were illegal or not. The case,
All right, plug in your cable.
the case was, there was a summary judgment case. We had an opportunity to appeal. We did not appeal. Some are very confident we could have won on appeal, but we did not appeal, but we lost the first case. So because we lost the first case, those homes were in fact legal, or are in fact legal. However, we created a law, which was 407-105, which made the homes illegal, What we're doing now is we're amending 407-105, which what that means is the homes continue to be illegal with the exception of pre-existing properties. So what is a pre-existing property? It happens all the time. When you have a code change, there's two options. One option is to grandfather the pre-existing use as a non-conforming legal use, or you can grandfather it, or the other option is to make it illegal.
So the current code stays in place as currently worded?
Yes, it does.
Okay.
We're only amending the one section of that code, and that one section is the 1 year period. That's the only part of the codes being illegal. So they remain illegal in general, except for the ones that are grandfathered, which is a very common practice in law and in zoning. Correct, Peter? Would that be the case? Grandfathering?
I think everything that you said is correct, and that's exactly right. So local law number 9 of 2015, among other things, amended chapter 407 to state that with the exception of bed and breakfasts, specifically authorized by that chapter, chapter 407, transient rentals or short-term rentals are not permitted in the following zones, and listed all of the residential zones of the town of Grand Island where they might have otherwise been permitted. So effectively, lawsuit ends. Option is you either continue the litigation. Well, the lawsuit's ongoing. The question for the board is you continue the litigation and potentially win there, or you can just fix the law and accomplish the same thing. Fixing the law, accomplishing the same thing was a lower cost and straightforward option. The board elected to do that and enacted local law number 9 of 2015. When you make unlawful going forward a use that had previously been legal, there's really two things that you can do. What's very common under the law is just sort of grandfather the use that was existing. In fact, in lots of sections of our current laws, we've done that. We say that we change the district from residential to business or business to residential, and the use that used to be lawful and non-conforming in that area, which the town makes no longer lawful, it might, quote, grandfather. And grandfathering of a use which has become non-conforming due to a change in the code, as the supervisor said, is a pretty common way to deal with it. You essentially allow it to continue for as long as it remains in place unchanged. When it ends, when somebody stops that use, it's effectively grandfathered out of existence, and you can't restart that use again.
So example would be maybe the Village Inn. That's maybe not a bad example. An example would be a restaurant in a residential neighborhood.
Yeah,
where
I'm not talking about a
that
specific person or case, but yeah.
But a zoning or a doctor's office, the zoning changes, and even though it's bizarre for that to be there because it always existed there, and it was continually existing there, the law grandfathers it in. Which is very
good examples are we've got a number of residentials in B zones in the town of Grand Island. You can look at all the business zoning districts throughout the town of Grand Island where you see business zones, and you might find a house there. And say, how can there be a house in a business zone? The law says all you can do is have a business in this area. It's not one of the things that's a permitted use. Well, at the time the law changed, the town would have grandfathered those uses which at the time the law changed were existing non-conforming uses. So that's one of the things that you can do when you change the law. You can grandfather uses. It's not required to do that. Another thing that you can do is effectively make the use essentially unlawful. You can say that even if it was okay before, you can't keep doing it here anymore, and that's perfectly lawful to do as well. The latter option is what the town chose to do in enacting local law number 9 of 2015 that effectively made unlawful going forward those types of uses. It gave persons who were engaged in those uses a period of time to recover their investment or otherwise transition the use of a 1 year period. It expires, I think, they'll hold me to it, but I think it's about October 15th. Those people are engaged in that use can potentially apply for an extension of the law the way it was put together in local law number 9 of 2015, and have some additional time to deal with that if they need to. But, so that's the history to where you are today, and the draft local law that you put together. So all those uses are, as of today, potentially lawful,
So-
arguably lawful non-conforming.
So I don't want to be pedantic, so to the town board, please forgive me, but just so everyone understands where we are, I just want to make it clear. So you have illegal, right? So actually the other way. So we have illegal use here, right? And then there was a lawsuit. We lost the lawsuit, so still legal. But then we made new law, which resulted in these homes being illegal. But we really had two options at this point. One is to grandfather, and one is to make illegal. What we're doing now is we're amending this law, which is saying that these type of homes are still illegal, but with the exception of a limited grandfathering.
Right, so the draft local law today essentially switches from the zone out of existence, making them illegal, to a grandfathering situation, but then uses the town's police powers to control the activity that those grandfathered uses could engage in. So you can't expand it. You would have those uses that are arguably existing today, lawful, non-conforming uses that would be allowed to continue as grandfathered uses subject to a licensing regime. That's the big picture concept.
So let's go ahead, Ray.
So before we even start, if there's a purpose/reason to grandfather
You can use that chair at the end to pull it out.
tourist homes,
Uh-huh.
then what I've heard about that reasoning is that it's good for Grand Island. It brings people to Grand Island. They spend money here. I'm not sure the other reasons.
That's the theory.
If that's the reason, and the town board thinks that that's a good reason, why are we limiting?
Well, I think I can answer that. I think what we're doing with the limiting, by the way, and I think the limiting, we have to provide evidence of continual use. If it wasn't continual, if it was I rented my room to my brother once for $25, they don't get in.
That's not the answer. To
But
my
I'll
question.
get your answer. I'll get there in a second. It has to be continual use. So there's not going to be that many cases. So it's a very limited number of cases. So we can quickly use this law, which we're all not that sure about, to test whether we can really regulate this or whether it's an uncontrollable nuisance. And also, it does it without us having to break the bank and making all of this legal, which is the other alternative. We can make everything legal, but instead we're grandfathering it in. So we're grandfathering in a limited number without unleashing havoc on the world, which is the two options we had here. Illegal versus grandfather, or legal, I guess, is the other option without the law. So it's allowing us to test, can we control this? Is it controllable? Does the grandfathering work? And if it works and it proves to be effective for the entire town, we can expand it. Or we can say, forget it, this didn't work. We had this mechanism in place that we thought a lot about, and it simply is not an effective way of grandfather. We cannot grandfather these homes in. It's not suitable for what we have on Grand Island. It's not working on Grand Island. So that's the theory.
Okay. Then the next question is, before we were even to go into this, how, who, where, whatever, are we going to identify the ones that are supposedly legal and should be grandfathered?
Well, it's you have to prove continual use. So you need
Okay,
so if someone
what's the
comes
proof?
in with no contracts, with no taxes paid, with no rental contract, nothing, and no evidence, we say, listen, you have no evidence that you were operating, and you have no evidence of continual use.
2015,
Right, you're not grandfathered.
Right,
2016,
one
2015.
of the things that I had, oh, there, no, that's Chuck's, that isn't mine.
But Chris, I mean, Ray, before you go any further, I think one of the other benefits is by doing this and allowing this mechanism to be in place to say, come forward and show us continual use, we are gonna very, very quickly, for the first time ever, really understand how many people are doing this. It'll weed people out quick and we can identify them.
On the
Weed and cap.
I'd like to continue to work on
Sure.
that
Go ahead.
because number 6, it says proof of owner's current ownership of the premises. And, oh, that's the wrong section. As a matter of fact, it's not stated in here, I don't believe, about the proof that it's necessary. Like if I go someplace, I need to show my license or a passport. Or I might be able to show a utility bill to prove my residence at a particular location. Have we decided on what proof we're going to ask for and what proof we're going to accept? And if we haven't, I think we should.
For the identify of the renter?
Right,
Yeah.
identify, have you had a operating tourist home? What's
Oh,
the
to,
criteria
for the
for
people
us
who wanna
to
be
determine
grandfathered?
whether or not you have had an operating tourist home?
I think one of the criteria would definitely have to be rental contracts and proof of,
I'm saying, I don't care what the criteria is.
Yeah.
The criteria needs to be stated. This is what we're gonna accept. We want this, or this, and it'll then tell us.
I would think it'd be some kind of a signed contract for 2015 in evidence of paying taxes for that business in 2015.
I think that sounds good.
I think those two things would
And
do it.
I wanna add, by the way, I'm not entirely convinced that these things are gonna be great. It might be a total disaster like it was in parts of the island previously. But I think if we have this law, we can test it on these grandfathered properties under these strict conditions and kinda get a better understanding of what we're dealing with here. No one understands how many there are, where they are, and we have no,
See, that's our problem.
yeah, right,
Because we think there are a few,
right.
but we don't know. So there could be 100.
I think it's highly unlikely we're gonna have that many people show up with evidence that they've been
Highly
operating
unlikely, I kind of agree
continually.
with you there,
Yeah.
but I don't know that to be a fact.
And neither do
So
I.
I'm gonna grandfather possibly 100 of them around Grand Island that are affecting their neighborhood in certain situations.
So Peter, on this,
So
how do we
with
prove,
With not knowing where they are, I don't know that I can vote for something like that.
Peter, how do you prove continual use? I mean, rental contracts, taxes,
Number of things. I know that I would specify a recipe of what you need. I mean, existing non-conforming, the fact of a structure being having the status of a lawful non-conforming use is something that has, this case law as to what, this comes up all the time in relation to businesses that are in areas that are zone residential and vice versa, whatever it might be. So it could be those things that you mentioned, it could be other things, and we could show there, I don't have rental contracts, I don't keep those, but I've got copies of the driver's license for everybody who's been here, and I've got checks that they gave me and in email exchange that effectively constituted, who knows what it might be, tax returns that show that they operated their home as a business over a period of time. It could be any number of things that might.
So it would be stated something like the fact of proof of ownership acceptable to the town board.
Yeah,
Yes.
and maybe it's, proof of continual use in a manner appropriate to qualify for a license under this local law.
That sounds like.
so if we're talking about what actually is gonna be in the law, he brought this up for this reason, so we can look at it and draft together. I made a couple recommended changes, I talked to Peter about it. Peter, do you wanna refer those to the board right now so they understand?
Can I make a suggestion?
Yes, sir.
Can I make a suggestion? We start from the very beginning.
Yes, sir, let's do from the beginning.
And as we go through, people say, I'm okay with that one, I have a suggestion on that one, and there might be 3 of us that have a suggestion on that particular one, I don't know. That way we're not jumping all over and we can
That works.
follow it.
Yeah, that
Say,
would-
So
Okay.
let me, just to begin with, I'll talk about section 1, and then Peter, you jump in.
We need to go higher than that,
So be it hereby enacted by the town board or even higher.
higher.
The town of Grand Island, New York, local law
It's-
intro number
it's
7 of
okay.
2016. A local law amending the town of Grand Island zoning code to allow non-conforming transient rentals or short-term rentals to continue.
Okay, so that's where I have a change,
Okay?
because we're talking about using tourist homes. We're not using short-term rentals anymore, we're not using transient rentals, we're not using this, we're not using that, we're using tourist homes. And every time we talk about this, because it's already been deleted in a couple other sections.
Yeah, I like that.
So I have to allow legal, non-conforming tourist homes. Boom, that's it.
That works, doesn't it, Peter? Yeah, I think that makes sense.
Yeah, if you use the word short-term rentals, that would cover bed and breakfast also.
Yeah.
Just, we're talking about tourist homes, it's a tourist home law, is it not?
Yep.
And
Yes,
let's
it
just say tourist homes, every place that we're talking about, it should say tourist homes.
Makes
Well,
sense.
local law, amending the town code of the town of Grand Island, the town of Grand Island zoning code to allow protection act with the zoning code, is it? Amending the town code of the town of Grand Island.
And Peter has the worst, most unenviable job ever, which is typing in front of a crowd of people.
Okay with that, I don't do that. So I'm making kind of typos there. Local law amending the town code of the town of Grand Island, I need to get rid of zoning code because there's other sections that are actually amended there too. Not all zoning. To allow certain.
No, to allow legal, non-conforming tourist homes.
How about allow for the continuation of certain lawful, non-conforming tourist homes? Try this. And they can edit it like that.
Does a title really hold any weight though, just out of curiosity?
No, it doesn't.
So it
I mean, the law-
doesn't, you don't enforce any words in the title, I'm just confirming if that assumption is accurate.
That's accurate, but I think it helps people understand what we're doing. I think Ray's suggestion makes sense and it's more clear.
Yeah.
Local law amendments
Sorry,
to
I think-
allow for the continuation of certain lawful, non-conforming tourist homes. Something like that, that's a.
Sorry.
Throw darts at it, but,
Mhm.
okay,
Yep.
got one in. Next paragraph, any concerns? So deleting 407-105. 407-105 is the section of local law, 9 of 2015
It's
that
the new one, right?
had the amortization thing. Yeah, right.
That's the 1 year amortization, right, yeah.
Yeah. And that had a few things in it. It said it gotta be terminated within 1 year. It's got the, application to continue up to 3 years, subject to.
But we're just terminating,
restrictions.
we're deleting.
Yeah, so
we
instead
don't
of
care.
killing it, you're going back up to the grandfather
Yep.
route. And what that leaves, to be clear, the section of the old local law that says that these things, with the exception of bed and breakfast, transient rentals, or tourist homes, are not permitted in the following districts. So those are all still unlawful in those districts. So essentially, you've made them unlawful, except instead of killing them, you now have a grandfather situation subject to licensure. I think that I would change the title now, I'm looking at it, to certain lawful non-conforming uses, and it is what it is. Try this, just from a legal standpoint. To allow for the continuation of certain lawful non-conforming uses. I don't want to necessarily characterize them as anything other than what they are.
They're tourist homes.
Uh,
We're talking about tourist homes. That's what this law's about. I think it's necessary to say tourist homes, because we're not talking about any other uses. We're talking about tourist homes.
well,
What other uses would we be talking about?
Well, section 351-4 tells what types of licenses are required. In
That's
addition
a
to tourist
different-
homes,
That's a different section.
right?
the section we made unlawful in the old law was transient rentals, short-term rentals, which was essentially any rental for a period of less than 30 days. And then with that, using that definition of transient rental and short-term rental, we said that they're not permitted in certain zoning districts. Here, we come up with a new definition of tourist home and essentially create this new idea of what a tourist home is for a period of less than 30 days. So it's clarifying definitions that were in the prior code that might have otherwise been construed as short-term transit rentals.
What if you just say certain non-conforming uses as set forth in herein?
Yeah.
So
something like
because we're explaining what those non-conforming uses are in this document.
Yeah, that's fine. It is, if something was a lawful short-term
Isn't the
rental
only
for
thing we're
existing-
talking about as a non-conforming use, in this particular instance, is a tourist home. There is nothing else that we're talking
As
about.
You're
currently
right.
Unless, if
defined-
there is, then it's hidden.
No, as currently defined, yes. Under the current definition of tourist home. What I'm thinking is what somebody arguably might have called it under the prior legislation or the prior legislation from 2 times ago. So if somebody might have argued that they had a lawful right to continue to exist under the laws that was written at the time, they might not be relying on the tourist home definition, they might say it's a lawful short-term rental. or if they want
So there was inconsistent definitions in the past that
And
we're
that
trying to
was part
trump
of
here.
what's relevant to the prior lawsuit. So anyway, what you've got, the only thing that you'd be allowing here would be something called a tourist home. You're amending the definition of tourist home as you're specifying here, and it includes transient rentals or short-term rentals, which are included in 407-10. So it's essentially this entire 30-day thing. But it's all within the new definition of tourist home as you see it in the local law. So not expanding into anything that was there, but an argument that somebody might have had might not necessarily have been under the tourist home definition as it existed, for example, in 2013, before you made any changes to things. That's why certain non-conforming uses is permitted here in, or something like that, might capture those folks that you're trying to capture, if that's the intent.
Quick question. I don't know, did you,
Not convincing enough for me, but
yeah,
I'm not gonna keep on going on it.
so a quick legal question. Does this open a loophole, or is there any risk of them being viewed almost like a monopoly on the island and provide an opening to try and expand it to other areas? By opening the door on this, could it result in other forms of tourist homes becoming legalized?
So because we grandfathered it here, people would claim that's an unfair monopoly, but we're only grandfathering it in residential districts.
Yeah, and the issue is with this, oftentimes when you eliminate a use that had previously been a lawful use, it's fairly, as Nate was showing before, it's a fairly common model to either to grandfather instead of entirely eliminate. We do that sometimes in zoning law. So when we grandfather, effectively, I guess, anybody that is grandfathered has a quote-unquote monopoly in the area. It would be, it might be the only business that's allowed in this residential area.
Doesn't
because
open a crack by which they can
Right, just
legally
because-
expand it.
Right, just because, you might be the only one of us that has a business located in a residential area, and, you've operated consistently, you by definition, have a monopoly on all business in that residential area. That doesn't necessarily give any of us a claim. You had a business before the law was changed.
What if they come in and give us proof and and you reject the proof?
I think that's a case-by-case basis. Now, there's a variety of things that you may or may not find acceptable. Somebody comes in, applies for a license, and you get the license requirements, you can decide you like it, you don't like it, you want to tinker with it. But it could be, there are so many possible formulations of what might be
So let's say they were
appropriate proof.
operating in 2013 and then they stopped and then they didn't restart, but now they want to restart.
Somebody might make an argument that I wouldn't want to offer an opinion without considering the full, array of stuff. Why'd they stop? Is it a seasonal rental? Did they try to rent during that time, but they're unable to do it? There's a variety of things that might be relevant or might not.
So there's a situation where, and again, we talked, I don't wanna sound pedantic, but there's a situation, the guy's a house that he was operating as a non-conforming use, that house burns down, he doesn't operate it for a while, he comes back later and rebuilds the house and says, hey, I wanna reopen as a dentist office in this residential area. He can't, unless we give him an exception. So the whole thing is, it's always a case-by-case basis, but we have to demonstrate that continual use is hard to demonstrate sometimes for a lot of people. I think there's gonna be situations here where we say, I'm sorry, but it's just not continual.
So on that note, if someone then sells their house, are they selling a tourist home, or would it then revert back to a normal residential house?
Uses run with the land, so as long as you could try to do something different, but the default answer under the zoning law would be a use is a use. So if I had a house that I was operating as a tourist home and operated consistently, and the board were to adopt this law, and I go out and I get a license, and then I sell my house, the person who purchases the house, if they want to continue the same business that I operated at my home, and they do so consistently, might be able to continue it. But if I sell it to you, and you said it's gonna live there for a few years, and then Bev buys it
Right.
2 years later, Bev couldn't reinitiate the use.
You
So it
broke the
doesn't go
chain.
with ownership, it goes with consistency of use.
So just to talk about that a little further, my thinking on some of this is that the initial investor purchased for this purpose potentially, maybe not in every case. And this grandfathering is to address that particular issue. Once they sell, the next buyer, would be going in with their eyes wide open that they're not buying a tourist home. Could we not design the law to, around that type of a
Try
concept?
that, it becomes more challenging to regulate transfers of property. I mean, one of the things about zoning is that it's presumed that zoning runs with the land. So, a use that you make lawful, you can't say, second you sell it to Bev, it goes to. Maybe we could through restrictive covenants or, like, thought about it, maybe see if we can find some ways to accomplish that, if that was something that was important to the board to look at, but that's not something that would be a default under the zoning.
So right now, everybody can come in with an exception, anybody. I ran a bed and breakfast, or I ran a tourist home 10 years ago and got out, now I wanna come in again, I can get an
That would be hard.
exception.
I mean, there's a few, you can cover some bright line examples like that. I mean, something you did 10 years ago would be very hard for us to say that that's continuous. Now, if you did it last year, but you didn't do it yet in 2016, but you've been on the internet every week, you've been trying to rent your property to tourists,
So
and
that's
just
how I
weren't
view it.
successful in doing
So-
it.
It would have to be two
So,
fifteen.
so I will say this,
2015.
I think it's a theoretical problem. I really think we kind of have a general idea who they are. There may be a few exceptions thrown in that come out of the woodwork, but we kind of know who's gonna be able to prove continual use. There may be some, there may be some outliers in there. Yeah, they've been paying taxes,
They're not
they
paying
have
taxes,
contracts.
they're
I think
not-
it's gonna, if someone comes in with some, crazy claim that, 20 years ago I rented my house out, I think you just say no. And there may be, the goal of this law, at least one of my goals, is to avoid any additional legal claims. Now, that may not be the case. Maybe we're creating more claims by
That's what I
this.
was thinking, because now you're gonna make exceptions for some and not the others, and then you're getting back to, are you limiting it to certain people and not everybody?
But-
I think if they come
Based
in with their
on-
income tax form and they haven't paid
It's gotta be
taxes or claimed it.
2015, yeah.
But there are grandfathered uses all over the island. It's very common to have this happen. It's not a monopoly, it's not something completely outside the lines of normal property law. It's a very common thing. And again, this law is so restrictive, I think it's gonna give us an opportunity to quickly determine whether this is a bad idea or whether it even works. Anyway, let's talk about the language of the law a little bit more.
Continue on through it.
So, okay.
So we should, does anybody have a question on the first page? I'm gonna try to expedite this, if you don't mind.
I'm fine.
Hold on. So the fee schedule is a separate document, and then we vote on that.
That's not on the first page.
Right,
Yes. But you're right, though.
yeah, it's the next page,
Is
sorry.
it on the first page?
That's 35-5A.
But
If
you're-
you wanted to,
Just wanna skip. Is the first page good?
Yes, sir.
I'm good with this.
Okay.
Mike, you're right, though.
Second page.
who's jumping ahead on you?
I'll start.
Go ahead.
On 351-5A2. Cross out transient rental or short-term rental, because we're talking about tourist home.
Develop the definition, that's a good edit. Capitalized term to be consistent.
And I think I made a mistake, but maybe I didn't read this as closely as I should, but I thought I went over it with a fine-tooth comb. I got down to 6, and it says proof of the owner's current ownership of the premises. And then I sit down what suffices for proof, but I don't mean ownership. That's pretty easy, it's a tax record.
Yeah.
I mean proof of the fact that they've been operating this business for a period of time, and I'm not sure where that is in here, so we can skip over that unless somebody else has the answer.
No, it's a good, so I started to put that, we're talking about that, proof that demonstrates status as a non-conforming use. Continuous operation.
Continuous non-preferring use,
Right.
And I would actually.
including go ahead, Mike.
I would say including within the last 12 months, evidence of
Yes,
operation.
yeah.
The month of the date of this law going into effect.
I have a suggested change when you're done with that too, Peter. I think,
Yeah, well, any others on this one? Proof to demonstrate continuous operation as a lawful non-conforming use?
Within the last 12 months.
within the last 12 months, including a rental agreements, should we say that? Rental agreements,
I would-
tax payments?
Tax payments
I would-
and ownership of the property. Because
Okay.
I think that's important too, because we want whoever it is to be, we should know if they're local or if they're from some other country, you know?
Well, that says proof of the owner's current ownership of the premises, so that's.
Right.
That's just from the tax bill.
Peter, one of the things I'd like to change is there's the name, address, telephone number, all that information. With the new website we're creating online, the new town website, I think we can create a database that has some of this information on there. I know other towns have done that. So I would suggest to the town board that we create that database so people can contact the owners directly if there's an issue.
That's in here.
Right, but is the database part's in there?
Yep.
When did we add that? That's not the version I have.
Three 351 6C11, is it?
Yep,
Registration
that's
records.
the one.
Yeah.
Submitted to the town, an online database shall be published with such
Okay,
information.
if it's in there, that's good.
Another question when we get there.
One issue that occurs to me as I look at this language is the current ownership of the premises seems a little bit odd. It should, a couple of things come to mind. Oftentimes people will, especially if you rent a property, you might put the property into an entity that you own or have service agreements where there's, different folks are involved with it.
4932 East River Road, LLC.
You might do that, you might have a lease agreement that gives, Joe Blow, the owner of the property, leases it to, whatever East River Road operating company that effectively runs all of the leases, whatever it is. So there may be folks other than the, owner that are involved in the operation of a tourist home as it's defined. So there's a number of things that presents in this. It might not just be proof of current ownership, it might be proof of current ownership, or lease or other property interests to identify to other authorizations to operate the property in a manner proposed, something like that.
So the question either actually comes, do we even need it?
Do we even need it? Well, you probably wanna know who the owner is,
Yeah.
so you probably wanna have that.
Well, the owner is a matter of record. It's on the tax bill.
Yeah, but rather than look that up, I'd like to have it there, but I'd also like to know who else is involved in the, so, you wanna know who's the owner of the property and, any of the individuals associated with managing the property in relation to proposed use. That's, I guess, what comes to mind. Something like that. I mean, I could edit that slightly to do it, but that's.
So I would add one more thing about the 12 months. I would actually say 2015, not the last 12 months, because someone could start a business tomorrow.
I said 12 months preceding the date of the application, so it has to be
Yeah,
lawful
no, I would say,
non-conforming. No, so if somebody comes in a year,
no, I would say it has to have been in operation on or before January 1st, 2016,
yes.
in
That
the
makes
year
sense.
of 2015. So between January 1st, 2015 and January 1st, 2016.
What a lot of these, yeah, I think that's good.
Or what date everybody thinks should be in effect.
Or from the date-
From the date of the law going into effect, 12 months back from that.
12 months before 407-105.
Correct.
Agreed.
It was,
Okay.
That was September, was it? Or so? I don't know on that one. Ray would know. Was it over a year ago?
I know what.
When the new law went into effect?
I can tell you the
I
truth.
believe it was October 15th, 2000.
That's
Oh,
late
okay.
last year.
2015.
12 months back.
That's something I could look up, so I don't keep that information in my brain. Not enough room, I
Gotta
got.
declutter. You're not a hoarder
Clutter it
like me,
Not enough
huh?
room.
We good on this page? Anything else?
We don't need to list the noise ordinance, that's a New York State law, I think, the 90 decibels.
Oh yeah, I think a lot of those subjective standards should be taken out. I think it's flirting at lawsuits, like Ray talked about previously.
Are we still on this page?
Yes, we are.
Where?
Well,
361, 5A, 5, yeah, number 5, right next to it,
Grand Island Code.
Just says you can't exceed the limits set forth in the town noise ordinance.
right,
We
so,
have-
so I'm just asking, should we actually specifically call out a noise ordinance? Because I think the two things that I hear the
Well, it's
most
already
about.
there.
Okay, the two things I hear most about is noise and smoke from a bad fire, where maybe they're burning something
Yeah.
rotten dirty, you know.
But
Agreed.
Usually there's
We
no
already-
fires.
We already have an ordinance,
When we go
right?
farther in this,
Books?
there's no fires.
Okay, did we actually say no?
That's in there.
Okay.
Right now it is.
Okay.
It
Unless
is.
we decide to change it. but-
No, it's in there.
So we're good on this page?
Yeah.
So I just changed, number 7, proof the owner's current ownership, or other property interest in premises.
That's right. Good enough.
Okay.
Also, proof of no, so this next page, proof of insurance. We're gonna change that, right? To show
Yeah,
like.
that's pretty vague.
What kind, how much?
Yeah.
I think we just keep it.
Whether the town's covered,
No, I don't think.
The
we
town
can
doesn't
do
have to be
town.
covered, I don't think, but I think what we need to say is per incident, 300,000, or just give a, a general standard that we can put out there. To say, this is, just something, I mean, what we don't wanna do is make this an insurance document that makes over demanding requirements. I don't think that's necessary, but I think if we put some standard in there, some minimum standard that will protect against, accidents on the premises.
So we're talking about liability insurance,
Yes.
so that's the kind.
by licensing, does it create any liability on our part?
Well, the
I'm
answer
sure
is
you can sue anyone for anything, Mike, but it's, I don't see, the fact of issuing a license upon somebody satisfying legal requirements for it doesn't in and of itself give rise to a claim. I mean, for example, the building department goes out and issues a CO to a building that, later has a problem. Sometimes people bring claims, they're extremely difficult to prove against the municipality, but it doesn't mean that sometimes claims don't ensue anyway.
Right.
This kind of falls in the same category. There's nothing that is particularly high risk by any means in issuing a license. Doesn't, keep it over too.
When we come right down to it, should we be doing that?
Requiring insurance.
We don't
Well,
require
there's a-
insurance anywhere else. If a
there's an
business-
argument-
If a business opens across the street, we don't require them to have insurance. If they decide not to have insurance, if somebody slips and falls on their sidewalk, well,
It's a
not my
good
problem,
point.
that's your
It's a good
problem.
point. It's a valid
Are we
point.
legislating things that we ought not to be legislating?
Possibly. Yeah.
I'd be inclined to pull it out.
Yeah, let's pull it out.
But it's nothing you can try it.
Here's the thing, and we talked about this. There's a severability clause in here, so if something is challenged later or said to be invalid, it doesn't kill the whole law. We can cut that part out, so it doesn't really hurt us to have it in there. But maybe you're right. Maybe it's in principle. Let's just take it out because the standard is vague anyway.
I would want it in there as if it covered the town, otherwise it doesn't make sense.
Well, it covers the town. It's
Just take it
private-
out.
It's private property.
I don't know if
My insurance covers my
licensing
property.
Somehow boomerang back at us.
Kill it. Let's kill it. All right. Moving
Next
on.
section on fees.
Yep.
I know that we don't want to identify it in the law, but before the law is enacted, I think we should discuss what the fees are gonna be, what we think we're going to have to pay for in order to implement this law, whether it's the actual review of the license and the granting of the license, and then the ongoing inspections, and then police response to any kind of situations, what that all may end up costing the town, and therefore a fee based on that amount. And it's just something we need to talk about.
Well, it has to only
Not
cover.
necessarily today.
It has to cover costs, but I think
Can't make
yeah.
a profit.
No, but we can do 2 inspections a year, plus probably additional policing,
Absolutely.
and we can do the admin costs of processing the permit.
Right,
So
so we need to
we can
kind of,
ballpark that.
we need to kind of come up with that and have that number
I
before
would-
we actually
Yeah.
vote on this
I would
law.
go further, I think also the legal proceedings, cause something's gonna happen.
Good point.
I think you gotta
That's
cover
good.
all the possible costs that, cause this is gonna be probably a headache to manage.
Yeah, it's going to be. Yeah, it's
I
gonna
don't
be
think
difficult.
the
And we'll
person-
probably have to cut some people out eventually. Some people are gonna show that they weren't able to abide by these standards. So yeah, I agree. Let's talk about that more and make sure we have those standards set out.
Agree.
So why don't we do this? Why don't we all brainstorm about what things we think should be covered by this fee? And then can we share those thoughts through over the next week?
And then these need, it doesn't have to be in your fee schedule, you don't memorialize all the background, but you wanna at least make sure that it's generally tied into a reasonable estimation for what those costs are gonna be. You know what the cost, including taxes and overhead and benefits and
And
everything
if
else
we,
for
and
an hour.
if we experience a situation where we don't believe it's covering the cost, we have the ability to change that
Change the
fee
fee
immediately
schedule,
without
right.
having to go through laws.
That's
Right.
That's right, there's only resolution to amend your fee schedule. And typically do that each year, as you know.
Guess I'll be the one to start all the time here. And C, number 2, it says whether the
There's a lot of
license
detail here that's not
will
necessary.
negatively impact the health and safety and welfare. I think it's whether the operation of the tourist home will negatively impact. It's not the license, it's the operation of the tourist home. And in addition to that, what would be the standards that we would use to determine whether or not? Or is that just kind of, we're just gonna leave it up in the air? Turn it off.
Well, a lot of it, we're listing in 1 through 19.
Where are you in the license, right?
I'm under
C, processing
Two.
application.
So, just take, it's a general catch-all clause saying, doesn't hurt the community type thing. And we can say, as determined by the recommendation of the advisory board.
It's almost a meaningless statement ultimately. I mean, if we really have no intention of doing anything related to that, because I think it'd be very tough to figure that one out.
It's actually, I mean, it gives the board some discretion, so I just changed it to whether instead of the license, the activity permitted by the license, but, will,
Okay, that's all right too.
will negatively impact the health, safety, and welfare. I mean, it's broad enough to be able to, you're never going to think of all of the things that might upset the neighbors. Some tourist and operator is gonna do something that
That you
you
never
can't
guess.
possibly envision as you sit around the table here.
Right.
So, having language which gives you some discretion to consider any factors that affect health, safety, welfare of the community might be useful. It's a broad standard, but this is the standard that, you can use in deciding whether to, deny an application. I mean, it's even more broadly hooked to the end than the other rational. The idea is to give the board broad discretion. You can certainly limit the discretion as much as you want. You can identify factors A, B, C, and D.
I think keeping that catch-all in there is good, because it helps us helps us deal with future problems and things we're not looking at right now. And we could amend it later if it becomes more specific. But I think having anything else we feel like it type clause is not a bad thing.
At the end of that, the statement, the approval or rejection, so on and so forth, I'm assuming that this is gonna be something that you can't put in with Peter, so you can tell me, like another sentence at the end if possible. All decisions of the town board shall be final and not subject to appeal.
We
there
can
you
put
go.
it in, but any
It's
determination
I
as
like
like
that.
somebody could pursue an Article 78
Put it
pursuit.
in all
Right,
lines.
so never mind, right?
Um,
Okay. I kinda figured that was the answer, but
Put it in.
I gotta ask the question.
Don't put it in. Okay. Any other comments on this page or any other part of this?
Yes,
Okay.
section 6,
Mm-hmm.
when it talks about occupancy. So I don't know if people know about the new Morgan farm. So if I were to buy the Morgan farm house, I'm gonna guess that there's a high probability that I would have the ability to have 8 rooms in that house. And if I did, why couldn't I have that as 2 people sleep in a neat room for 8 rooms for 16 people.
Because, well, I don't have a good legal reason for that. I can tell you that when I looked at the other laws for other cities, a lot of cities said they capped a maximum number.
Maybe
For
a
whatever
septic
reason.
system wouldn't hold it.
Yeah. So,
That's true. That's a good possibility, but at the same time, maybe
What's that?
the septic system was built for a 4-person household, and Erie County's gonna say, no, you can't have any more than 4 in that household, no matter what. So, that's an Erie County health question, if you're building, if you're operating a tourist home that's not a septic system. Okay, I don't have a problem with that, I was just asking why,
and
that's all.
it just simply, it came out, and I think you can, Peter, you agree with this, that this is generally a standard used in a lot of towns that have these laws, that there's a maximum number.
I don't know if 12 is, I can't tell you that this is the norm, but I can tell you that,
There's no way you're gonna police that anyway.
capping the intensity of the use
You're
is
not,
something. that should
because
be-
I'm gonna bring people in, and I'm gonna put 3 kids in a king-size bed, and it's gonna be 3 people in a room, and nobody's gonna know the difference.
How do you get to 12 besides with number 2? If there's 5 rooms.
I'm just doing the math myself.
Yeah.
Oh, 2 persons per sleeping or guest room plus 2 additional per property, that's it, so it's 10 plus
Oh,
2.
12,
Yeah,
yep,
I
got
get
it,
you.
thank you.
I guess you could put that in, it's just gonna be very, very hard to enforce it. Okay.
Well, you know, to be perfectly frank, all of this is hard to enforce. That's the big challenge. How do we enforce it? But I think the benefit of the law again is that we're able to find out where these are, who they are, what's going on, and we can get a better understanding of what we can do to regulate it, or if we can regulate it at all. If we can't,
With the fees, though, I think it does give us the enforcement capability. And we should be held responsible to make sure that's happening.
Yep.
That the police are going by, that the code enforcement's going there a couple times a year.
Yep.
And that we're keeping a good track of what's happening.
I think we should put that in the law, that the code enforcement has to do 2 inspections a year. I think that, is the town board opposed to us fitting that in somewhere? I think if we write that out in the law, we make it a legal requirement, we're mandated as well.
You could put it in C. Or you could, or, yeah, maybe it doesn't belong there.
You could just put it off to the side, fit it in at some point where it belongs.
Maybe under D, issuance and duration, and then.
And not limited to,
periodic inspection.
right?
Yeah, not limited to, right.
So I can show up and say, I'd like to see your register,
Sure.
and if there's 14 people on the register, you go, why are there 14 people on the register?
Right, and you can refer the matter to the board and get the, yeah.
That's fine.
What do you say, 2 per year?
2 per year, and also, I think you should also keep, required to keep a list of
I wouldn't
document.
say 2, I would say periodic. I like that word better. Because if you
Minimum
have a
of 2?
problem, you could say a minimum.
Yeah,
of
minimum of 2, and then as required.
2. That way at least we're, got a standard, yeah.
And I think they should also keep an
Keeps
ongoing,
us-
an ongoing
At least we get
record,
there 2
an ongoing
times.
record of problems of the property. So we have a documentation, because the problem comes when we try to remove the license and someone says, you're taking my property right away from me. That's exactly the problem we have right now. So if we document the history, through the inspections, through the complaints, and we have a documented history of what's been going on, it's gonna be easier to take away licenses if we have to later.
So do you wanna specify 2?
Yeah, I think we should specify in the law that the code enforcement folks have to keep a record of the properties and the complaints on the properties. So we
What
have,
about
at
the
least.
frequency?
Just at least. And then the other ones are periodic, so the periodic is whenever I decide to get there, because I need to be there because of complaints, or just coming because it's one of the 2.
right,
About that. Inspections will be conducted or determined by the town not less frequently than twice per year, or biannual, or whatever it is,
That's all right.
or semi-annual.
That's fine.
semi-annual.
Do you see a typo there?
T-H-A-T.
You're being graded, you know.
Secretary of
It's a
Fire,
teacher.
RP.
It's the teacher part of it.
Thank you. Don't hesitate to call out other ones, by the way. Fortunately, I'm a better lawyer than I type it. Anything else here? That language okay? okay, periodic inspection
Yeah.
after. Okay, so on performance standards, we did 1, 2, any issue with 3, that's the number of guests. That would be in addition, that's like the people wanna have their first and ever party, I guess, you
Right.
could have
Yep.
no more than
We're gonna
6
have some
people
people
there,
over, I
but-
just did it. We had, 11 people staying at the house, but I wanted to have my wife's side of the family over afterwards. So we had another 8 people there to kinda hang around at night, have a glass of wine, and then everybody went home.
So you have up to 6 and more
And I get, they
by
get to ask
special
it.
permission.
Right.
I was there, I'm at all the race parties.
Number 4, in second sentence, for single-family dwellings, only the residence and legally established guest house. But later on, it says, outbuildings, guest houses, or other accessory structures shall not be leased, subleased, rented, or subrented. So why does it say and legally established guest house? Why wouldn't it just say only the residence meeting current standards shall be used as a vacation rental? I mean,
No, so
meaning
it's
everything.
separately, so you can rent, let's assume I've got a house and a guest house. I could rent out the entirety, if I wanted to, the house and the guest house. The entirety has to be rented together. Guest houses, outbuildings, whatever, can't be rented separately, so I couldn't rent one to you, I couldn't have multiple going on at the same time. We can clarify it if it's not as clear in that regard, but, so for single-family dwellings, only the residence and the legally established guest house, if you've got one that meets standards to do that, like it's got a bathroom in it, whatever, can be rented as a vacation unit. The entirety of the property must be rented together.
So what you're kind of saying is if there is a legally established guest house on the property,
Yeah, if-
then the residence and the guest house can be used, but they must be used together.
Yes.
Then they can
By
leave.
the same person.
You can't rent your shed out.
You can't separately rent them. Outbuildings, guest houses can't be rented separately from the main building.
Yep.
So, like I see this last part here about tents and everything else,
Yurts.
I laughed when I saw that. So let's say someone got a bunch of or a couple of kids, I mean, you wouldn't allow them to have a tent? Well, as long as what if you're staying within the 12 maximum, you wouldn't wanna have anything like that, huh?
I don't think you want tents.
I want people outside.
What about
People with-
motorhome too? Is that okay, recreational vehicle?
That's a good question,
Is
Chris.
that a motor,
That-
is that
right,
the
that-
same as?
Mhm. We got into that discussion before about
Mhm.
house trailers, wasn't that, Peter? Wasn't that the
Oh, yeah.
terminology we had problems with?
Indeed.
House trailers and mobile homes and whatever.
I think we ban all that from the property unless it's being used to
Yeah.
drive there in.
What's our definition? I don't have my code in front of me.
Yeah.
Remember, Peggy, when we were working on that, that was a big mess?
Well, seasonal recreational vehicle.
I could see people
Or
driving
be
up in a
considered recreational
motorhome
vehicle.
though, and then renting out the place, I don't think you can restrict that, can you? As long as they're not staying inside the motorhome.
I think that's it, yeah,
as
right,
long
yeah.
as you can't
If they
stay
drove
inside.
there in it,
Yeah.
Right,
fine,
yeah.
yeah.
We just need to use our definitions that are in our code, probably 407.
Yeah, 155-18 deals with recreational homes and,
And paved surfaces, huh?
yeah. 155. Yeah, recreational vehicle is defined as vehicle built on a single chassis, 400 feet. So that's in relation to this whole thing about. Damage prevention has a definition of recreational home, which is, I think that's dealing with the replacement home after a flood. That's not really maybe relevant to us.
Shouldn't that just be under our definitions, beginning of the chapter?
Let me go to chapter 407 and see if there's any definition of campground is those recreational vehicles, so we do have a definition. Mobile home includes any self-propelled recreational vehicle in the manufactured mobile home section. Let's go to 407. Campgrounds talks about pre-owned recreational vehicles, issues of permit, recreational vehicles. A permit for storage.
travel trailer motorhome definition.
That's the one.
Any
That's,
vehicle used, designed
Yeah.
for, or capable of being used for sleeping or living quarters, mounted on wheels or capable of being mounted on wheels, whether propelled by its own power or the power of vehicles to be attached, so that'd be a
that's.
travel trailer and
A fifth wheel,
or a recreational
right,
vehicle.
that's what we
Jack,
want,
you
that's
go.
what we want to use, what did you say?
What section you in?
What's it called?
Motorhome,
Motorhome,
use the-
that's what we want to use, we want to use motorhome near
motorhome,
that RV.
or travel trailer.
Motorhome or travel trailer?
I'm in, travel trailers and motorhomes, 3848.
Although that does allow for it to be on the property, yeah, regulations for travel trailers and mobile homes. But just basically, that already says you can't live in it. What are we saying about it here? Let me just go back.
You can't sleep in it.
It just says they're not permitted. Can you park one there?
You can park them,
Yeah.
you can't stay overnight.
To be used as sleeping quarters.
That's covered elsewhere. That's already in 386.
Oh, okay.
Should we, can we repeat it here to make sure it's clear?
We could. Just worry about doing that. This is a procedure there to allow people to stay in it and keep them there for more than a certain period of time.
Or occupied. And it's the occupied.
Or doing that elsewhere.
Well, running those out in the driveway.
They are.
My sister stayed in a travel trailer in a driveway in Portland,
Wow.
or in, Seattle, about a month ago.
Wow. So then we definitely have to make this clear.
1969 retro,
That's nice.
Airbnb.
I'm gonna rent a tent in my backyard here.
It was really
There is
cute.
one currently
It was
on the
super-
island advertised,
It's really cute.
Okay,
a mobile home.
okay.
Really?
We good with that one?
So, well, what are we saying?
This will make
We
it
just
easy.
want to say not permitted for,
This will make it
to
illegal.
be used as sleeping quarters.
What about tiny houses?
There have to be a non-conforming use. They have to prove they're already in existence, and they've been going forward, and they've been doing it. I don't know where any tiny houses are on the island. I mean, again, well, let's hold a discussion among the town board, I'm sorry, but just to keep it efficient.
Other neighborhood standards regarding trash bins?
Yeah, that's on here somewhere, 9.
Yeah. I mean, there is nothing that says you can't leave your trash bin out for 5 days that I'm aware of.
Well, if it's empty, that means it's being stored out by the road, so you can't do it.
Okay.
That would be my interpretation of that.
It's just
If it's out there to be collected,
Yeah.
and it's
I'm
been
on
empty,
Number 9.
Actually, before you get to 9, we have some comments on auto. So
yeah,
for
right,
parking,
we're back on 5.
yeah, parking,
No problem with that.
okay. Noise limits,
6,
I
okay.
might kill this actually, since there's a,
Refer to the local law.
chapter 230, it's from 7 AM to 7 PM, and it's got specific decibels and limits. If we wanted to have noise limits here, we'd have to define them with the type of specificity that we use in chapter 230.
Don't,
do,
there's
do you have to really line up with that, or can you go a little tighter?
You could theoretically go tighter, but
I would rather go tighter.
How are you gonna prove it?
same way we do the other noise stuff, it's not easy, but we
Meter,
have a guy, we've got
who's gonna do it?
now our code guy's got one of those gizmos, and he has, but the right way to measure it, it's gotta be decibels at distance. So you gotta be able to measure 90 decibels, at a certain distance from the property line. And that's what we do when we enforce the existing code section. And it's pretty carefully written in that regard.
10 PM to 9 AM.
Do you have 230 in front of you?
I do, I'm just pulling it up right now. So, let's see the limitation noise. Yeah, so it's like, daytime noise, 7 AM, 7 PM. There's different standards for transient noise and steady noise. Basically, steady noise between, transient noise is a 7 AM, 7 PM time frame. And then steady noise is what's is actually more significantly regulated. And then 65 decibels in the daytime and 50 decibels in the evening. And for that purpose, evening is 11 p.m. to 9 a.m. Not 10 a.m. And there's
10 to 9.
in this exacting detail about, you know, an ANSI type 2 standard regarding the meter read and how exactly to do it and distance and all kinds of stuff so you can measure it.
So we're at 50, right?
Yeah.
And just starts at 10 at a tourist home instead of 11.
And ends at
Something.
9 rather than 7.
Well, no, the nighttime is 11 p.m. to 9 a.m.
Well, I know the first one, is here to quiet hours from 10 to 9. I'm not sure, is that no noise or what's the decibel limitation that's contemplated there?
It says the noise limitations are set forth in 240 are applicable. So you'll limit the noise limitations, meaning 50 decibels, per usual stated.
Well, okay, the noise limitation set forth in chapter 230 applicable, we could say, except that, you know, table 2, whatever, shall be amended so that, you know, make it apply to 10 p.m. or something if you wanted to, instead
That
of,
makes sense.
instead of 11. Or you could just delete it and rely on the same standards that you've got elsewhere and say they're applicable.
I think it's nice to actually have it in here. And if somebody needs to refer to 230, they can refer to 230.
Okay,
So, I know we're still going through this, I'm gonna just throw a thought out. Is there any way we could require a fence to demarcate the property line?
I'm going to suggest a little later, Mike, that these places need a special use permit.
Yeah.
And in granting a special use permit, the town board has the ability to sit down and say, we need some certain things. In this particular piece of property, we believe a fence is necessary.
a fence may not be the right answer, but
That's correct.
this, yeah,
It's just
something to demark the property, like a sign, just denote that it's not, you know.
whatever it might be.
I prefer a barrier or
Yeah, but, you know, we have, if we have, there's other, when you go to look at our schedule of permitted uses, some things are just plain permitted, you can just do them as long as you're doing it according to code. Some things are permitted under a special use, home occupation. You have to have a special use, bed and breakfast, it's a special use permit. That allows, first of all, you have to have a public hearing, so people have an opportunity to say something about it. Number two, we then, as a town board, have the ability to set parameters in granting that special use permit, one time. We can't go back and say later, oh, you know what, you need to put up a fence, we need to do it at the beginning. But I think these kinds of situations need to have that special use permit process.
I do like actually specifying a fence. So I think I would like to see that actually in the law requiring a fence to demarcate the property line.
Oh, we do have situations that were brought to our attention, at least to my attention, of situations where the people, no matter what the owner tells the people that are occupying the property, the people occupying the property really don't care.
Exactly.
I'm leaving in 2 days, I don't care, I'll just run across your
That's why I
property and
think
go.
a real barrier
Make a
is
difference.
necessary.
So, But what that comes down to then is an enforcement situation where our code enforcement goes out there, or our police go out there, whatever the case may be, and if that's being a violation, we need to have some parameters, this is coming later, we need to have some parameters of withdrawing the license.
Well, we don't approve it without a fence, is
Well,
what
I
you
don't
do
know.
in that
Well,
case.
Again, each one of these are individual, that's why I think we should have a permit. Special use permit. But that's getting off the track, we're still on
Yep, go ahead.
noise limits.
Gotcha,
We done with that?
I think this works.
Oh, wow.
That's
That's
what
what
it
you're
looks
on
like.
now.
Noise limitations are applicable except the tourist home operation shall adhere to quiet hours from 10 p.m. to 9 a.m. and thus limitations and noise specified in section 230-3 of the town code shall be applicable except that as applied to tourist homes, table 2 of section 230-3 shall be modified to reflect nighttime hours. That's the quieter hours is running from 10 p.m. to 9 a.m. Oops. PM to 9 AM, and daytime hours, that's the louder decibel range, should run from 9 AM through 10 PM.
So I think this provision in particular, if enforced, will solve a huge number of the problems. Because most of the problems I've heard about are noise at night and, you know, noise in the mornings when people need to go to work, et cetera, et cetera. And I think you will quickly weed out a lot of the grandfathered uses through this clause alone. If it's not being, you know, maintained in the way that fits into a residential neighborhood.
Maybe it was amplified, yeah.
And number 7 doesn't really work.
Maybe just kill it.
Kill it.
I mean, an amplified sound is like, I mean,
Yes,
like it's
this-
hard,
this
right?
is-
You
this
know,
is
like
a-
streaming
If I
radio.
play my phone, it's
Yeah.
an
You
amplified
can't
sound.
hear it, it's
Or you
amplified.
play, yeah, this is
I mean,
a,
doesn't the noise
The
limits
noise,
thing
the
cover
noise
it?
Yeah.
covers it.
this, we have enough.
7 out.
Okay.
The pets, on the other hand,
Kill the pets too.
no, a barking pet could drive you bananas.
But that fits into the noise, doesn't it?
Whole
No.
thing, no, it does, we've got a whole thing on dogs
We-
and dog barking.
We do, but
You know,
I think
where-
it's good to have it specific in here to let people know that if you have a pet,
It's gotta be.
they're
called
gonna
out
be
in there.
secured on the property at all times and shall be prevented from creating a nuisance such as continual barking or continual noise, including barking, and we can delete the second sentence because it's redundant.
We have to define pet now, which is probably,
So who's gonna
It's-
enforce that on the weekends?
well, we have the police as well.
I guess we have a police. We have dog control
We have dog control on the
and we
weekends.
have police. But if it's a cat meowing too much, that's not a dog, is it? So we're gonna have a problem.
Hurts.
What, can't we just ban pets from the properties, from these properties?
Oh my gosh.
Or no, is that?
No, I love dogs and
So do
cats
I.
and things like that, but there are people that do not go anyplace without their
Got
pet.
All right.
They carry them in a basket
That would be one of the.
or something like that, so.
Yeah, so, I mean, what, we've got limitations on, again, it's noise and distance, right? So noise ordinance covers the sound of a dog barking and decibels and how continuous it is, there's just one bark. And then we also have engage in barking, crying, whining, or combination thereof for 15 minutes or longer within a 1 hour period. Provided that it's quote audible beyond the property line, that's just dogs.
Okay.
Engage in, permit a dog to do these things.
So it's, we're not, when we talk about pets, we're talking about dogs, essentially.
No, we're talking about anybody that brings anything as a pet.
But the turtles aren't gonna bark all night.
Parrots might cause a problem.
Pygmy goats.
Someone said coyotes.
Peacocks.
Kill dogs.
Think if we just make it pets, it's simple. Whatever you bring as a pet has to be secured on the property and can't cause a nuisance.
So what we have to define pet? Is pet defined in the code somewhere?
A non-human.
Yeah, non-human.
A non-human.
Yes, so if you
It's
bring
gonna
your
be disturbing.
snake, you can't let it
Um,
loose.
Okay.
It has to be contained.
If you have a 20-foot boa, it could be a nuisance if it gets loose.
I'd say so.
This is the,
All right, so instead of continual barking, that's probably too vague to have as a thing, but that's dealt with elsewhere, what's continual, like how when you hear them. Audible beyond the property line.
so just get rid of the word pet and just put your non-human shall always be
No, we'll
restricted.
just say
No. No, I'm telling you, pets has to be described, has to be defined.
Why is that?
Why do you
Because you're gonna think somebody's gonna bring something back that they're gonna say it's
consider
not my
one of your
pet.
friends a pet or
Oh,
what?
well, no, because we have to
Or
understand,
pet.
we have to understand what the scope of, pet could mean.
It can be anything.
What-
That's why you want it wide.
I could bring an elephant as a pet. I mean,
As long
I'm
as
being
it's
stupid,
quiet.
but
All right,
honestly,
all right.
if I have this little baby elephant that I'm allowed to have,
Peter, are you
probably
confident,
illegal,
are you confident the word pet alone stands on itself from a legal basis?
My only issue with pets are access animals of different kinds, we have to make sure that they're excluded.
Right,
So
Oh,
somebody who's.
yeah,
got,
somebody
like,
who
a
needs
seeing-
seeing eye dog
or
or,
whatever, and
They
they're
wouldn't
probably
be
still
barking.
not.
Even
let
nowadays,
loose,
don't
but
people
they-
have the authorization for companion,
Yeah.
pets, right?
okay,
So.
Pet.
But at the same time, the restriction on them should be the same. They should be secured on the property, and they shouldn't be creating a nuisance in the neighborhood. And no doubt that they won't, because.
it's
if they're
not a big
companion
issue
pet,
with me, I just wanna make sure we're not,
Yeah.
okay. If we can define it and we think it works, Peter, I'll trust your legal judgment on it.
Well, let's see, prevented from creating, just creating a nuisance is kind of vague here. Creating a nuisance, subject creating a nuisance,
That's fine.
in a manner prohibited by applicable law, or how about just how about this? creating nuisance such as continual noise or other behavior, including barking, which is otherwise made unlawful under this code, or something like that.
That works, then we can refer back to
Or
the
in a manner
provision.
otherwise prohibited under
Right.
the town code.
Okay,
Otherwise prohibited. I think that works better. You can't just outlaw a nuisance. I mean, I don't mind if a dog jumps up on me and my wife hates it.
Okay.
Alright.
I'm okay with that. How about other people?
Should be landlord or managing agent, it's not always going to be the,
that works.
landlord, managing agent, or other responsible person shall provide contact information, something like that.
Mhm.
I have a question at the end of this. It's not part of the law. My question is, who's going to establish this and update the list?
I would assume it's gonna be on our new website,
Yes, yeah.
But who's gonna be in charge of doing that?
so we would receive the name, and I think it's just a simple submission to whoever's doing the upload.
We can
for
do it.
us.
Cindy, the supervisor's office can do it.
Okay,
Yeah, we can do it.
all right.
Just 2 minutes.
I mean, I don't imagine a huge flow with these, so, yeah.
Right, it's gonna be a one-shot deal, you know.
Yeah.
And number 11, these registration records, which I assume if the house is being rented out, it could be on a weekly continual basis. Where is this stuff going? Who's gonna update it? How often is the record get filed? Like, the record must be at the house, right?
Uh-huh.
So, once I rent my house for 3 days or a week or 2 weeks, do I need to turn that in? Or do I just keep that in a book at the house?
I think we keep that at the residence
And then it's available upon request?
upon inspection by the code enforcement guys.
Right.
Yeah,
Okay
that's
with
what it
that.
says, yeah.
Yeah, except not final available for inspection.
Well, it doesn't say on file where though.
At the very, oh, yeah, I should
The-
say
the-
by the.
the
by
landlord or the-
landlord or property manager.
Right.
That's the licensee. That's just a licensee. How much do you guys really care about soap?
I don't
As we
care about
talked
it.
last time,
Yeah,
11 and 12 are standard lists, and, 12 and 13 are
13,
standard lists and
take them out.
unenforceable, we just need to get rid of them.
Done.
Yeah, we said to remove it.
Guys, Greg Butcher has the stuff that you need to do the resolution for the fire hall thing. Do you want him to come here now, or do you want him to wait?
Yeah.
Wait upstairs.
Upstairs.
Yeah, wait
Board
upstairs.
act on it tonight?
Yeah.
It's okay, we can do,
Something.
we have to suspend the rules, that's all.
Two of the resolutions have already been made, this is just the final one after the public hearing.
Okay.
So let's do it right at the end of this. How about that?
So down
Or
here?
upstairs, we can do it upstairs, it's not a
Okay,
big deal.
we'll do it upstairs.
It's one way, it goes in the other. Well,
Alright.
it's probably
Suspend
better to do it
rules,
upstairs.
yeah.
I have something on 16, something, got something before that.
What was 16,
It says a licensee, rental agent, or manager shall maintain an up-to-date 24-hour contact information at the town clerk's office, so on, so on, so on. Person so identified shall be responsible promptly, and I said this last time, promptly can mean 2 days, depending on what your idea of prompt is. So I think there needs to be
Specific
a
time.
specific time in there, and lastly, should this be in a database? Because that person that needs to be contacted, or is it not necessary to be in a database, it's just something
I would think
town
that
hall
would be
needs?
included in the database, the phone number,
It's
address.
not stated as being included, the owner and other information.
Well, why don't we, let me take that and put it up next to the other, by the way, to start with, because,
It makes more logical
it
sense.
makes more sense to
Yeah.
put it there, doesn't it?
use, and this is one that I know about, is that if I'm a certified pesticide applicator and there's an apprentice working for me, I have to be able to respond to that in 30 minutes. So that person could be working on a different property, but if there's a problem, I gotta be there in 30 minutes, or I gotta be able to respond, I gotta talk to the DEC officer if he's got me on the phone. I don't know if that's applicable in this situation, it's the only one I can come up with that's familiar with.
So can we combine, so maybe it's easier to look up here, combine 9 and 10 into one? So I've got contact information for somebody, it's all the same people
Yeah,
that we want,
I
right?
think so.
So let's just call it, just call it licensee contact information. So that's required. And then the direct phone line.
So
Just think
10 is almost redundant, isn't it?
Yeah. Maybe promptly, we're gonna say the promptly immediately, promptly.
No, he wants a specific time, so within X amount of time. I don't know what an appropriate time would be, I mean, I would just be pulling it out of thin air.
Well, the issue's different things, right? Some might be like trash and recycling facilities, they're stored within view. Could you build something or do something so that we can't see them
Or
anymore?
or can you take care of them? Yeah, I can get
But
there.
but others are, they're having a party outside, they better knock it off right now, and that would probably show up with the law enforcement guides, but they wanna be able to see if somebody who's, not somebody who's away and is gonna say, on 24 hours, I'll deal with it. It needs to be somebody who's gonna show up immediately and deal with it. So prompt might mean different things in different circumstances, right? So,
Yeah,
you could say promptly, but in no event later than 24 hours, something like that,
that works.
something like that.
Not if it's a nuisance that's happening right now.
Yeah.
It needs to be, somebody has a fire going outside.
How about,
According to this law, you're not supposed to have a fire going outside.
how about immediately, just get rid of promptly,
Yep, there you go.
immediately address compliance issues, and what do we think immediately means? You know, maybe it's, build a berm or something, it can be done after these people leave,
Yeah.
but
Respond immediately, and then
Respond
resolve
immediately.
maybe possibly later.
That'd be all right.
All right.
okay.
Anything else?
So I would like to have the fence idea actually incorporated in there, to demarcate the boundaries of the property. Minimum of, waist high, so maybe 3 foot.
Well,
I'm gonna think about this for a
yeah,
second. Mike,
yeah.
if I own a piece of property that's 7 acres,
Yeah, but,
that's a really
but your
big
vacation home,
fence.
I would just say the boundaries of the vacation home, around the yard or whatever. I mean, you're not gonna say the whole 7 yards, or, I understand what you're saying, yeah.
Well, let me add one other thing, another wrinkle.
I still
We
think,
can always,
In a lot of
I think-
situations, a fence is considered an eyesore, or is not, there's communities that have lawsuits over these fences all the time because it doesn't meet the flow of the grass. I mean, if you put a fencing requirement to say you have to have a 3-foot fence that's gonna surround this place, you might have more complaints than you have solutions.
It does present other issues. We have a lot of issues with these fences along properties in the water. And the adjacent property owners have a real issue because it interferes with the view.
their view.
So if you've got somebody who's renting out the neighbor's house, they might,
I think we have to do a case by case
Can you
situation.
demarc-
If there's
cause,
problems.
'cause that's what I'm hearing is, people are wandering into other people's yards, playing in other people's yards, all this stuff is going on, and they have no respect, cause they're gonna be gone in 2 days.
If
That's
we
what
have
the,
that
that's what the
situation,
24,
the public hearing that you hold for the special use permit, that can come up, and the town board could then say, that issue needs to be addressed. How are we gonna address that issue?
So if we could put that in the, so I like your idea, but use that as a specific example in parentheses. For example, a fence may be determined to be required.
But you wouldn't put that in a code usually, something like that. You would usually, I mean, we can say subject to special use permit. Special use permit in and of itself will have certain requirements about how the property should be used. I'm not
You
trying
might
to.
say,
I mean, I've been at
the
some
neighbor
of the,
may would rather have a bush or a hedge rather than a fence, or, you know what I mean? I think
so
that
I mean,
is-
just by providing an example, that still leaves it wide open. You can determine what the appropriate, but something is some kind of a barrier. Because there's some
That's what we have,
places
that's
that
what
are
we have,
just so
Mike,
wide
in
open.
a special use permit situation, the town board has the ability, correct me Peter if I'm wrong, to put parameters on whatever they feel are parameters they need.
Right.
It could be, you could just pull it out of thin air, something that's kind of, you would expect to be ridiculous, and you say, you know what, I think you need that in order to protect the adjoining property or whatever the case may be.
Okay. So really what we're saying is, before each one of these properties are approved, there's gonna be some kind of a special use permit required, is that what you're proposing, right?
That's what I had in,
Or we jumping ahead?
So I recall, especially, you're talking about a hearing and following the same procedure, that's really what you have in mind, right? 'Cause it's not a
Oh, I
special
know.
use, 'cause it's a license, but it's, you can get the same place.
in our matrix of R1A, R1B, et cetera, et cetera, et cetera. It talks about principal uses, it talks about accessory uses, it talks about special uses. So as you go through those, you would insert where bed and breakfast is and stuff, home occupations is, you would insert tourist home. So tourist homes would be required to get a special use permit, which requires a public hearing.
Okay, so two options there. You could do that. If you were to do that, tourist homes wouldn't be limited to those which are grandfathered uses that previously existed. It would be, you can only, if you wanna make it a special use, it just means a specially permitted use, i.e. a use that you obtain special permission of the board to engage in. If you do those things that you need to do to get it, you get it.
We actually put it in the matrix.
You'd have to put a matrix.
That would be
But
allowed.
you could effectively get to the same, if your concern is, I like the procedure that we have for special uses. We have a hearing, public has an opportunity to come in, comment, whatever. You could establish the same framework that you have for special use permits and have it applicable to these particular types of licenses.
So we just need to insert that into here.
The mechanism into
somewhere.
your-
You just
Such
insert the
section.
hearing procedure and, as to processing of applications, it would just be down the bottom where we've got these things, there's gonna be a procedure where there's a committee, and the committee does this kind of stuff, and powers and duties. We just add a requirement in that, it'll, same way we do for other types of things, that there would be a public hearing component of it. And maybe there's a public hearing
I think there should
first,
be.
and then it gets referred to them, or vice versa, similar like we do on the planning board for certain types of things. The town board has a public
Just
hearing,
like a bed and breakfast.
referral.
Yep, okay, I understand what you're talking about there, so we can incorporate that somewhere.
Yeah, and
So
if you wanna
in
talk
the-
about screening, I think I put it right here. Impacts to nearby property and, potential,
Need for screening.
yeah, screening or opportunities to mitigate the risks, right, including screening and other, impacts and, let's see. Or on proposals to mitigate any such impacts.
So in the interest, I wanna jump ahead a bit, I'm sorry, cause it's almost
Yeah,
8
we gotta
o'clock.
go straight, right.
So are there any other major concerns? I think we covered a lot of the big things.
Termination clause,
Okay,
because I don't see anywhere in here where we say, okay, you've had 5 violations, now it's time to say, sorry, but we're yanking your permit or license.
it says any action in the next clause. Peter,
Make
you know what I'm talking about?
recommendations to town board for action.
Where's that?
Right here,
Where are we?
back page.
At the back page, where it says what they can do.
See,
I thought the
That's-
same thing,
that's
but
coming
Peter
from-
pointed it out
That's
to me.
coming from the committee.
right.
Yeah, that's the approval
We're talking
process.
about D, violations. The only thing that's on here is violations of this chapter should be punishable with a fine of $1,500 and up to 15 days in jail or both.
We can
That
put-
means if you have an outdoor fire, you could get, notice of violation, order to remedy, and explain to the judge why you had an outdoor fire.
Comma, let's just add, or up to including the termination of your license or your permit.
Right.
Okay.
Is that okay, Peter?
Sure,
What?
Sure, yeah,
That
we could do
makes
something like that, that would have to be on notice and opportunity to be heard, so license is annually renewable, so every year you have to do it, so it can't be more than a year anyway. And then you've got this procedure down here for, so violations should be punishable by 15 days in jail or both, and potentially revocation of, revocation, suspension, license, something like that.
Yep. Then I think that's everything.
Now, are we going to have any written parameters to figure out whether or not a tourist home license is to be suspended or revoked? You know, we talked about the 3 strikes are out, you were talking about the 3 strikes you're out, we're gonna use 3 strikes you're out.
I think
We're
we
gonna
can
use 3 strikes you're out, or how are we gonna do this?
I
Because-
think depending on the circumstance, it could be 1 strike, you're out.
Uh-huh.
If it's a severe circumstance where someone has like motorcycles all over the lawn and it's going nuts, it's up to us. I don't think, I mean, unless Peter thinks it's wise to add some kind of, you know, formal mechanism, 3 strikes you're out or something like that, I would like to leave to the discretion of the town board after consulting with this committee.
But because
We can
the other
have some
risk
guide-
is,
We can have some guidelines, though. I know in our, I'm just gonna go to my HOA, we have rules for everything, but there's, and wind chime is not a big deal, you know? But if somebody drives their car across the line, digs it all up, that's a big deal. You know, there's different severities,
Okay,
so
well.
I think maybe that we should work something out, so at least we have a guideline. We don't want somebody saying, well, chewing gum,
Yeah.
a complaint doesn't make for a violation.
no,
There could be frivolous complaints, there could
That's
be
right.
It has to
valid
be
ones.
substantiated,
It has to be substantiated.
a violation of something here that's substantiated.
and
Right.
some
Peter,
are
by the
really
way,
severe
you
violations,
do
and some
something.
are,
So
Yeah.
we're not judges, but we kind of are judges. So when things come to us, we have to make decisions. It's, you know, there's gonna be a little bit of discretion in all of this. And when someone comes to us with an issue, we can have the discretion to decide together whether or not to take action.
Number 15,
Guys, you're gonna have to.
Okay,
number 15, short-term rental and transient